is with Ellerby Thompson. We've had a long-term relationship with him with the GMA HR hotline, has a great deal of expertise in employment law and other things. The sad news for everyone, he is a graduate of South Carolina University, but I'm sure he is a Dogs fan at heart. But with that said, Reed, if you want to take it over.
Well, thank you, Dan. And let me assure our attendees that while I am a Gamecock, I sent my son to University of Georgia in Athens, and my daughter is a senior at Georgia Tech. So I'm trying to spread it around and make everybody happy. So hopefully that scores me a few points. Dan, thank you again for allowing me the opportunity to do this. As you mentioned, we've had a long-term relationship with LGRMS and GMA and ACCG, and I think I looked back that we've been doing the personnel liability seminar since at least 1993. That's as far back as I was able to go and find the materials. And so this is I guess a webinar version of what had traditionally been the live presentations that we've done. But again, we've been blessed to have this long-term relationship with your organization, and look forward to many years going forward as well. So quickly about myself, I'm a labor and employment law specialist with the Ellerby Thompson firm. We're a labor and employment firm based in Atlanta. We do some complex litigation work as well. We have a well-established, long-term established public sector group that I joined as soon as I joined the firm back in 1989. And I've been co-chairing it with my partner, Sharon Morgan, since, I guess, for like the last 15 years or so. And so I'm a labor and employment specialist with a subspecialty in public sector employment law, representing primarily local governments, but the occasional state agency as well. And one thing that I do enjoy labor and employment law. The public sector side of it is particularly interesting to me because it allows us to get into some constitutional issues as well. I like to tell folks that our public sector clients have got pretty much everything they have to contend with everything that their private sector counterparts do in terms of federal and state laws, rules, and regulations dealing with employment issues. But on top of that, we've got some things that we have to contend with that are sort of unique to the public sector. And most of those have some basis in the Constitution. And this is a great example of it, drug testing. Drug testing has been determined by the U.S. Supreme Court to be a search, just like a search of a vehicle or a search of a home or a pat down of a person on the side of the road. And so consequently, the Fourth Amendment is implicated. Well, as you probably know, constitutional restrictions don't apply in the private sector. So this is a very unique aspect of employment law for state and local government employers, because we have to be concerned about the Fourth Amendment implications as well. There's various forms of drug testing, random testing for safety sensitive positions and that sort of thing. We're going to focus on one here this afternoon, which is reasonable suspicion based testing. And this is the type of testing that really applies across the board to any employee of a state or local government employer. So let's get started with this. First of all, I want to go over very quickly the learning objectives that we hope to get through today. Obviously, we're going to talk about what substance abuse is in the context of substance abuse testing in the public sector workplace. Substance abuse is a broad term that can mean different things in different contexts, so we want to define it for this context. We're going to talk about what reasonable suspicion is for purposes of substance abuse testing in the public sector workplace. We're going to drill down into that definition a little bit and talk about objective observations, as we'll talk about reasonable suspicion determinations have to be based on objective as opposed to subjective observation. So we'll talk about what that means. We'll drill a little down further into it and talk about the difference between crisis observations and non-crisis observations or performance-based observations. This is more of a federal DOT concept that's not necessarily required to be part of employers that aren't subject to those regulations, but they make some sense, and so we do cover them here. And then we'll talk about documentation related issues relating to time frames for certain steps to be taken, and then try to wrap up with some practical considerations, some catch-all points that hopefully we'll be able to cover. But if we don't get into all of that, they are in the materials that Dan has indicated he's going to be making available. And I'm more than happy to answer any follow-up questions for the next couple of weeks that anyone may have regarding the presentation, because I really don't want anyone to have any questions or lack clarity on any of the things that we're going to be talking about here today. Okay, so let's start off with workplace substance abuse and what we mean by that in the context of drug testing. And so generally speaking, or broadly speaking, it's the use or the misuse or the abuse of any substance. I know that's a vague term, but any substance, whether it's an unlawful substance or a prescription medication or even an over-the-counter medication, that can negatively affect an employee's judgment or an employee's ability to properly and safely perform their job duties. So getting a little bit more specific with the definition, workplace substance abuse refers specifically to the use or abuse of alcohol. So that's the use of alcohol in the workplace or while on duty or immediately before, or the abuse of alcohol under circumstances where it actually bleeds into the workplace. The use of illegal drugs, that's easy enough to understand, I think. And then the misuse or abuse of legal drugs, which includes a number of components, including the undisclosed, and I'll mention what that means in a moment, the undisclosed use or the overuse of an over-the-counter medication or a prescription medication that has known side effects which impact the judgment or which raise safety concerns. Okay, the overuse of prescription drugs, which means in excess of the prescribed dosage. I'm one who might get into trouble with something like that because I figure that the prescribed dosage is for somebody who's about 150 pounds lighter than me. And so I'm bad to come up with my own dosage sometimes. That's not good. And then lastly, the use of prescription drugs for which the user has no valid prescription. And that's also, I think, easy enough to understand, but it's when maybe a spouse or a roommate has a prescription for something and either allows the other person to use it, or maybe the other person just helps himself or herself to it under circumstances where that person, that employee, does not have a prescription for the medication that's being taken. Now, it's important to understand when we're talking about prescription medication in particular that it's not prohibited for an employee to appropriately use a prescription medication. In fact, we would never want to interject ourselves as employers between the healthcare professional and how they treat their patients. But the employee must discuss the potential side effects with the doctor, with the prescribing healthcare professional, especially focusing on the prescription medication's potential to impair the employee's mental functioning, the employee's motor skills, or the employee's judgment. These are the concerns we talked about a moment ago when we were defining what we mean by substance abuse. So we do impose this expectation on our employees that when they're prescribed something, that they'll pay attention when the prescribing healthcare professional goes into these side effects, or they'll be sure to ask questions about those potential side effects if they're going to be taking the medication or under its influence while working. Anytime a prescription medication has the potential for such a side effect, meaning it might impair mental functioning or motor skills or judgment, then we need the employee to report that in accordance, hopefully in accordance with the policy that we have in place, and also to refrain from performing any sort of safety sensitive functions, that may be compromised as a result of the medication. So not everybody has, just speaking from experience working with both private and public sector clients, not everybody has a policy that explicitly requires the disclosure of prescription medications that have these types of potential side effects. And a lot of clients are understandably nervous about getting into those types of questions because of HIPAA issues and ADA confidentiality issues, and that's understandable. But bear in mind, it's not necessarily required in this context that you know why the medication is being taken or even what the medication is. I mean, if the employee it discloses that these are the potential side effects, that ought to be enough for us to act and make sure that the employee is not engaging in any sort of activity that could be compromised as a result of the medication. And again, if anyone wants to discuss what a policy might look like that speaks to that particular issue, I'm happy to talk to you about that as an extension of this presentation, as an extension of this webinar. After we're done, my contact information should be in the materials, and I'm happy to, as a courtesy, to follow up with any of you about this. Now, under the U.S. Department of Transportation regulations, I want to talk about something that comes up a lot relating to medical marijuana now that Georgia is recognizing or starting to recognize that, as well as these CBD products that are showing up all over the place. As most of you probably know, the federal government a couple of years ago backed down a little bit on what it will permit in terms of THC content, which is the aspect of cannabis that causes the high or has the potential to impair folks. There's a tiny amount of THC that is permissible now in these CBD products that are being marketed for various purposes. The federal government has come out and has very strongly stated with regard to both medical marijuana and with these CBD products that if you are subject to their DOT or other federal regulations that require suspicion-based or reasonable suspicion-based testing, if you test positive, and the reason is because you have got a prescription, or in this state, if you have a appropriate certification to allow you to use medical marijuana, or if because you used a CBD product and you trusted the label that said it had no THC content or said that it had legally permissible trace amounts of THC, under the federal rule, that does not matter. The medical review officers are directly admonished under these regulations and the guidances that have been issued pursuant to these federal regulations that they cannot change a positive test result, even under circumstances where they've determined that the positive test result is occurred because of medical marijuana that was being taken, consistent with state law, or one of these CBD products. Now, there's nothing that says that local government employers have to adopt a similar stance when it comes to medical marijuana or CBD products. Most of the local government clients that we've worked with in the last couple of years since these issues have come up have decided to treat the issue the same way that it's being treated by the federal government. And there's a lot of reasons why that makes sense. we've developed some notices that we'd be happy to make available to you, that we've sent out to that we've given our local government clients to distribute among their employees, putting them on notice that these CBD products or even the medical marijuana are not recognized exemptions from the city or the county or whatever the client is substance abuse policy. So if any of y'all are interested in anything along those lines, that's something that I'm more than happy to provide you as a follow-up to this webinar. I'll also mention that when Dan makes available to you this PowerPoint, on this particular screen, the words medical marijuana and CBD product in the bottom half of the page should be live links to documents that the federal government makes available, very short guidances that describe their positions on those issues, and you could adapt those over for your own purposes, or like I said, we've developed some as well that I'd be happy to share with you. All right, moving forward. Okay, the next topic that we're going to talk about here is what is reasonable suspicion for the purposes of substance abuse testing in the public sector workplace. And when I initially put this presentation together, I went into some detail for the legal background of it, and decided that really couldn't get this thing done in an hour time if I went into too much detail about it. But as I mentioned earlier, it is a Fourth Amendment concept, and it's based on the reasonable expectations of privacy that individuals have against searches. And as I said, the Supreme Court decided many years ago that drug testing is a form of search. But at the same time, it's sort of a balancing test. What the courts do when they look at these challenges under the Fourth Amendment to any kind of search is they try to determine whether or not the interests of the government, or in this case, the governmental employer, outweigh the privacy interests that are protected by the Fourth Amendment. And in the context of criminal matters, they're, because of the potential that the citizen or the individual may lose their liberty, their freedom, be jailed or arrested or stand trial and that sort of thing. The standard that has to be shown in order to justify the search is reasonably high. It's this probable cause standard that we've all heard about. But in the context of workplace drug testing, because we're not talking about a criminal standard, and we've got very serious legitimate concerns regarding workplace safety in particular, we have a lower standard that we meet, which is this reasonable suspicion that we refer to with regard to this particular type of drug testing. So here again, if the employer has any sort of reasonable suspicion of substance abuse on the part of the employee, then that meets the Fourth Amendment standard and justifies the search, or in this case, the drug test. So going back to the slide, in the context of workplace substance abuse testing, reasonable suspicion refers to the belief that the employee may, it says is under, but I think it should more properly say may be under the influence of or impaired by drugs or alcohol, based primarily, and we say primarily here because there's another way that reasonable suspicion can be formed, but the primary way is it's based on objective observations of physical or performance-related or behavioral factors that are characteristic or at least consistent with substance abuse. And I'm going to go into some examples of these three categories of the types of objective observations that are characteristic or consistent with substance abuse and can thereby support a finding of reasonable suspicion. And these reasonable suspicion is something that's determined on a case-by-case basis. So we'll talk a little bit about what that means, but what's reasonable suspicion, what sort of objective observations may support reasonable suspicion in one instance may not support it in another instance. Okay, so as I said, that is primarily what we mean by reasonable suspicion, that it's based on primarily based on objective observations, but it can also be based on reliable, verifiable information or other specific, describable, and timely evidence of substance abuse, such as direct observation by the, let's say, by the supervisor or by a reliable witness of the employee's use or possession of unlawful drugs or alcohol, or possession of drug or alcohol-related paraphernalia. So this type of direct observation doesn't necessarily mean that they're under the influence of substance, or they're impaired, or that they've even not necessarily used it if they're just in possession of it. But these are considered to be objective factors that can be taken into consideration in determining whether or not reasonable suspicion existed. I have a pretty good idea what drug-related paraphernalia might be, rolling papers for marijuana or some of these pipes and everything. I was trying to figure out what alcohol-related paraphernalia might be, and the best I could come up with would be like a flask or something. And then I looked down and saw that I happened to have about 6 or 8 shot glasses on my desk here. So that's probably enough to get me in trouble right there. So I'll have to put those somewhere else after the webinar. In addition to direct observation or by a supervisor or by a reliable witness, there's also other factors such as, let's say you find out, the supervisor or the employer finds out the employee is under investigation or has been arrested or charged with a drug-related offense, or most especially an on-the-job alcohol-related offense. So they're pulled over for DUI while they're on the job, or even driving a city or county-owned vehicle. These are obviously the sort of issues that can justify reasonable suspicion, particularly if they are combined with other objective observations of potential impairment. If an employee tampers with a drug or alcohol test, it's perfectly fair and appropriate. And in the federal context, it's even necessary to infer from that they tampered with it because they've got reason to believe that it'll be a positive test result, and so acting on that basis is appropriate. And then, of course, the employee's admission of substance abuse. That's not something that we've observed. That's not something some reliable witness has observed. That's the employee telling us himself or herself, and we absolutely are allowed to act on that. Okay, so let's talk a little bit more about what we mean by objective observations. Again, this is the primary basis for forming reasonable suspicion that will support drug testing in this context. So let's talk a little bit about more about what we mean by that for purposes of determining reasonable suspicion. So I guess the first thing to point out is that when we're talking about objective observations, we're really speaking about the opposite of a subjective belief, which is a gut feeling or just intuition or just a sense that something's different about somebody, or somebody's acting in a way that makes you feel like there's something going on there. A lot of times these gut feelings and intuition are pretty valid, particularly with the more experienced individuals that have been supervising for a long time. But ultimately, from a legal standpoint, subjective beliefs don't really get us to where we need to be in terms of justifying the privacy invasion that's associated with drug testing. So we need a little bit more in order to establish that we've got what we need in order to justify the testing. Objective observations, in contrast to these subjective things, objective observations refer to the employee's circumstances in real time. In other words, contemporaneous with the situation that we find ourselves in. They focus on what's currently going on with the employee, such as the employee's physical or the employee's performance-related or behavioral issues at that time. And when I say at that time, I mean while the observation's being made, or the alternative form of objective observations that can support reasonable suspicion, the verifiable information or the reliable evidence that is presented to us as the employer that the employee may be under the influence of or in possession of drugs or alcohol in the workplace. These need to be timely. A great example, I've had a couple of instances where clients have called because supervisors have seen on Facebook, for example, that an employee is clearly intoxicated or very impaired for some reason, at a wedding or some holiday party that's unrelated to the workplace, or after a football game or at a football game even. And they want to know if they can act on that. And the answer with regard to employees who are not subject to random testing is no. I mean, if that's on their own time, and it's 2 or 3 days or even older, it's not contemporaneous enough. It's not timely enough to allow us to act on it from a reasonable suspicion standpoint. All right. So let's talk a little bit about some very specific objective observations that can support a finding of reasonable suspicion and thereby support drug testing on that basis. Now, this part of the presentation can actually be used as a checklist, and we do encourage our clients to use checklists or provide checklists to the supervisors or the other folks that you depend upon to make these reasonable observations and determine whether or not reasonable suspicion testing is appropriate. The checklists kind of focus you, and they also ensure that you're more likely to be applying these things consistently to employees, because that's one of the problems we run into, is that employees will often claim that they're being treated differently in some form or fashion than their colleagues when they're told that they're going to have to be subjected to reasonable suspicion-based testing. So the more we can rely on forms and checklists, the better we are at showing that that these are in fact objective observations and there's nothing subjective that's being applied here. So focusing first on the physical factors, walking, standing, or just the general movement or their motor function. So here's a number of issues. I won't go through all of them, but are they able to walk? Are they falling or almost falling? Are they staggering, stumbling, swaying? Do they seem to have poor balance? Do they have to hold on to something for support? Standing, are they able to stand? Are they sagging at the knees? Are they doing anything like spreading their feet a little bit farther apart than they normally would in order to try to provide some additional stability? Of course, all of this is based on observations that are being made of physical factors that don't normally exist with regard to a particular employee, because obviously the employees could have other reasons why they have difficulty walking or standing. And so if these are issues that they have for some other reason, then that's nothing to be overly concerned about. But we're looking for contrasts in normal behavior here, particularly in this instance with regard to physical factors. With regard to motor function, their general movement, are they being lethargic or uncharacteristically slow or methodical in their actions? Lack of coordination, delayed reaction time, do they seem to be nervous, trembling, that sort of thing? Continuing with physical factors, the face is sometimes will provide evidence of substance abuse. Are they pale, flushed, puffy, swollen, sweaty? Is there a confused or blank look? The eyes in particular, are they dilated or constricted? Bloodshot or glassy, watery, partially closed? Does there seem to be some involuntary movement of the eyes there? The wearing the sunglasses inside or under circumstances where the the employee normally wouldn't be wearing sunglasses, or the conditions don't really seem to support wearing sunglasses. That's as an individual item, and a lot of these as individual items are not enough to warrant reasonable suspicion-based testing, but when combined with other observations, they can get you there. And again, that's a good reason to go with the checklist, because it'll allow you to add these things up. Speech is another good indicator. Is it slurred or incoherent? Slow and deliberate? Rapid, uncharacteristically subdued, meaning quiet, or is it loud, rambling, slobbering? Breath and body odor. These are some things that are really difficult to conceal sometimes, and frankly, folks that engage in certain forms of substance abuse just stop caring about these types of things. Is there an alcohol odor or some other strong chemical odor? Marijuana odor. A lot of us have been around marijuana, know what it smells like. Urine odor, or anything else in the nature of a body odor that suggests that the employee is no longer taking care of themselves. All right. So let's talk about some performance-related factors. And again, we're going through what's essentially a checklist of items. Initially talking about physical issues, now we're talking about performance-related issues, and there's a lot of overlap here, which I recognize, but that's necessary. So while performing routine tasks, is the employee displaying forgetfulness, poor concentration or attention to detail? Is the employee having difficulty or seem to be uncertain or displaying some confusion or anxiety with regard to routine tasks? Is the employee sleeping or nodding off? On the other hand, is the employee having difficulty sitting still? Just seems to be bouncing off the walls almost. Interactions with coworkers or supervisors can also provide objective observations to support reasonable suspicion-based testing. Are they unusually or uncharacteristically argumentative or irritable or hostile? Do they appear to be overreacting to criticism or instruction? Or if a coworker tries to help them out with something, are they displaying difficulty maintaining their train of thought? And then attitude-related issues. Are they uncharacteristically uncooperative? Are they making an inadequate effort to do their job? Do they seem to be overexcited or over-enthusiastic? Or the opposite of that, do they appear to be uncharacteristically disinterested in what they're doing? Again, all performance-related items on the checklist. All right, the last of the three categories of objective observations that we've been talking about is behavioral factors. And again, lots of overlap here. So I think wearing sunglasses under suspicious circumstances would fit here as well. But the first category we have are attempts to conceal breath issues or odor, other types of odor. Is there heavy use of breath spray or breath mints, chewing gum, air freshener? Perfume or cologne, again, uncharacteristically for a particular employee. Personal interactions, this is also something we look at with regard to performance-based, but it's also relevant to behavioral factors. Are they withdrawn or evasive? Do they seem to be trying to ignore or even hide from others to avoid having any sort of interaction with them? When they're involved in an interaction, do they have difficulty making eye contact or seem to be avoiding trying to make eye contact during conversation? Are they, on the other hand, are they unduly talkative? Is there excessive laughter or laughter that just doesn't make sense, just bursts of laughter? And along the same lines, unusual amount of profanity. Some folks, depending on the substance that's at issue, they will sometimes display a lesser form of, what's the word I'm looking for? They'll be less inhibited when it comes to the choice of language. And so sometimes you'll hear a lot more profanity from somebody that's in a substance abuse situation. And then lastly on this screen, demeanor. Are they uncharacteristically nervous or jittery or easily startled? Do they seem to be hyperventilating or hyperactive, paranoid, erratic, any other form of abnormal conduct? On the other hand, are they overly subdued or passive, drowsy or sleepy? Again, these overlap a good bit with some of the other factors, but I wanted to give y'all a err on the side of over-inclusion in terms of the checklist type factors that can support objective observations. And again, the more of these that you can check off on your checklist, the better, the more likely it is that reasonable suspicion will be supported to justify requiring the employee to submit to testing. One last point here under behavioral, personal appearance, hygiene. Again, so depending on the substance that's at issue here, folks will sometimes lose interest or assign a lower priority to their appearance. And so you'll find clothes being dirty, wrinkled, torn, not being repaired if they're missing buttons. Grooming tends to deteriorate. Hair might be unkempt. They might not be clean shaven. No longer wearing makeup, or makeup is applied haphazardly or in a way that's not consistent with how it's normally applied. And then the body odor, again, that's a very telling issue, because when folks stop caring for themselves, this is one of the consequences of it. And also some of the substances that tend to be abused will also affect the body odor, even if they are showering and otherwise tending to their hygiene. All right, again, when the PowerPoint is made available to you, you'll see on this screen there are some links to some checklists that are online. I've tried to make mine as comprehensive as possible, but if you want to start from some actual formal checklists, the Georgia Department of Administrative Services has a checklist that it's sort of a model checklist for all the different state agencies to use, and that's the first one I've got on here. A number of colleges and universities throughout the state have some pretty good checklists, and I picked one I thought was pretty good that Middle Georgia State University has in place. And then I've even the Department of Transportation for folks that are subject to its regulations. They've got a checklist that I've put on here as well. And then more broadly speaking, there are some good model substance abuse policies available online. I've put links to the one that LGRMS has on its website. You'll have to log in first before that link will work. And then GMA has a model too that I think is good. And part of that is because I think I helped draft both of those, but we'd be happy to work with anybody on tailoring any of these model policies or model checklists to your particular needs if you want to give me a call in the next couple of weeks after the seminar. Okay, I think because objective observations are so important in determining whether or not we've got reasonable suspicion of potential violation of a substance abuse policy, it's also good to focus on what is not an objective observation. And when we first talked about it, I said, the opposite of an objective observation is a subjective observation or a subjective feeling. And that is what this is. We're going to elaborate a little bit. An objective observation is not a hunch. It can't be based on gut feelings or intuition. And that's not to say that hunches and gut feelings and intuition aren't valid. It's just to say that they are subjective and therefore they can't factor directly into this analysis. They might justify a supervisor paying closer attention to a particular employee if the supervisor has a hunch or a gut feeling that something's going on there. They don't have to ignore it. They just can't act on it exclusively. They have to have a little bit more. That would warrant their paying a little bit more close attention and seeing if they can't develop some objective observations that will support their subjective feelings and thereby support reasonable suspicion-based testing. Now, this next point is important. Objective observations can be based on inferences. Now, an inference is a fact that you draw from some other fact, but the inference has got to be reasonable, so it can only be, the fact that it's drawn from has got to be reasonable. So, an example that we put here, because this is actually one that we had in the last couple of years, you cannot draw a reasonable inference that an employee may have a substance abuse problem based on the fact that the employee's son or daughter was suspended from school, or suspended or kicked off the football team or the cheerleading squad because of drug use. You can't assume that because something like that happened, that there's a good chance that the employee himself or herself is also involved in the use of unlawful substances. That's not a reasonable inference to draw, certainly not in the context of trying to decide whether or not we've got a reasonable basis or a reasonable suspicion for requiring drug testing. This last point, also very important: objective observations can't be based solely on hearsay, gossip, or anonymous tips, but you don't have to ignore these things. Sometimes there's a legitimate reason why somebody wants to communicate information anonymously. I'll be the first to admit that when something like this is anonymous, that does undermine its credibility or its potential credibility. But you don't have to ignore these things. It's sort of like this first bullet point about the hunches and the gut feelings. You can't rely on those to require testing, but you can rely on those as a basis for some additional scrutiny, maybe paying a little bit more close attention and just trying to see if there's any validity to the hearsay or to the gossip or to the anonymous tip. So they don't have to be ignored, but they can't be acted on by themselves. By themselves, they're not going to support reasonable suspicion.
Hey, Reed.
Testing. Yes, sir.
So I got a question here. Personal time versus company time. How do you handle an instance of an employee participating in behavior on their personal time, such as at a wedding, but the effects are seen at work the next day and they may still be under the influence?
Well, if the effects are seen the next day, those are objective observations, and depending on what it is you're seeing, that may well be enough to require reasonable suspicion-based testing. We're not, again, we're not getting into trying to police what employees do in their personal time, but when an employee's behavior on their personal time does bleed into and affect their their behavior or potentially their reaction time, or otherwise impact their judgment, or otherwise create potential safety issues in the workplace, then we've got a reason to be concerned about it. And so absolutely, I would take that question and say that if we've seen on Facebook, or we attended a wedding ourselves and saw the employee there, that part is somewhat incidental, because we're going to focus on the behavior, the appearance, the physical appearance, the behavior, and that sort of thing in the workplace, and that in and of itself may provide the reasonable suspicion that we need in order to require testing. Because as we all know, you can certainly engage in these types of behaviors in your personal time in such a degree and so close in time to when you're supposed to report for work that you're still under the influence when you do report for work. So I would say that the behavior during the personal time is sort of incidental and beside the fact. As long as we're focusing on what's going on while the employee is on the job, then we're good to go.
One more question, Reed.
Yes.
And this is going to go back a little bit. Would you please ask him to share that with us? And she was referring to a document you mentioned earlier. It was, let's see, it was in regards to employer statements about not accepting medical marijuana or levels of THC from CBD while the employee is on duty. Do you have anything like that we can share with the group?
I do. And I'll just defer to you on the best way to get that to you. But we've got notices, because obviously that's one of those things we want to give fair notice to employees about, because if it's legal for them to use medical marijuana, or it's legal for them to use a CBD product, at least assuming the CBD product doesn't exceed the federal limits on THC, then it's reasonable and fair to give them notice that these are not exceptions to our substance abuse policy. So we've developed those forms, and the federal government has them also for DOT regulated positions. But I'm more than happy to make those available after the seminar, after the webinar. Just tell me the best way to do that. And
if you could just send those to me, Reed, and I'll distribute it to those folks.
Absolutely, absolutely. I'm happy to do that, and I think that's a good idea, because you know, some of these folks will have, you know, pretty credible arguments for you know, that if they weren't on notice that this was prohibited. So it is good to circulate these notices. All right. Let's talk real quickly about what the federal regulatory folks refer to as crisis observations versus non-crisis observations. And again, this is a concept that we don't really see too much outside of the context of federally regulated positions, but it makes some sense, and so I thought I would incorporate a little bit of it in here. Crisis observations, and remember, we're talking about subcategories of objective observations that may support reasonable suspicion that an employee is under the influence or otherwise in violation of the employer's substance abuse policy. And so we've broken this down into two categories. The crisis observations are those that support the existence of an immediate threat to safety, or indicate, you know, an immediate set of circumstances where the employee is under the influence, intoxicated, or clearly impaired by some sort of substance. And so immediate action is required. That's why the word crisis is used here. That's probably not the best word, but they're trying to make you as an employer or folks that are supervisors responsible for making this work on the front lines treat it as very important. And what it means is you've got to act right then and there to get these folks out of any sort of safety sensitive situation or other situation where they could harm themselves or others, or even damage whatever it is they're doing, you know, work-wise. It doesn't have to necessarily be a safety threat. It's just the sort of thing that requires immediate action. And it's immediate action even if you can't get them tested right away. You know, at some point, if too much of a delay, you know, requires that you just forego the testing. But you may not be able to arrange for testing for several hours, which is not ideal. But you can't let somebody continue to work, particularly in a safety situation, when there's a crisis observation suggesting that they're impaired or intoxicated at that point in time. So a crisis observation is one that requires immediate action, even if that immediate action does not include testing. Non-crisis, or what they call performance-based observations, are those that usually by themselves are not enough to lead a supervisor to conclude that there's reasonable suspicion of substance abuse. It's normally the sort of observation that you need a pattern of. It's going to require some time to assess before the supervisor is comfortable finding that there's a reasonable suspicion to believe that there may be a violation of the substance abuse testing policy. So under those circumstances, it's non-crisis. You're just paying closer attention. You're observing. You're using your checklist. And at some point, you'll get to the point where, well, presumably you'll get to a point where you're able to make a determination one way or the other, whether or not there's reasonable suspicion to believe that there may be a substance abuse issue. And as soon as that reasonable suspicion determination is made, then you do have to act immediately. So there's still a promptness or an immediacy associated with non-crisis observations, but those types of observations recognize that it might take several days of observations before you're able to reach that conclusion. But as soon as the conclusion is made that there's reasonable suspicion, then you need to act promptly. So these are the two categories of observations that the federal government recognizes with regard to its regulations, and I think it makes some sense to incorporate this into how we train and what we require of our frontline supervisors. So I'm not going to go into these, we're running out of time here, but I think if you look back at materials, if you want to get a sense of what crisis observations are versus non-crisis observations, you'll see that a lot of them are pretty obvious. Some may be less so, but review the materials and you'll see what they encompass. Okay, moving to documentation. Some of this is based on the federal regulations that they require for the positions that are subject to their DOT and other agency regulations, but they're all common sense, and really none of them would be contrary to what we would recommend for our clients that aren't subject to these regulations. And again, I can't emphasize enough how important it is for supervisors to use uniform employer-provided forms and checklists, because that really makes it less likely that an employee is going to be able to credibly challenge whether or not they were treated differently. The various observations that are made are going to differ probably from employee to employee, but as long as we're using the same forms, we're in a better position to fend off any arguments that somebody is being treated differently. I think we've already touched on this. The federal regulations require that the documentation be prepared within 24 hours of the observation. And the reason for that is that documentation, the credibility and therefore the usefulness of documentation of this nature really starts to wane and get weaker the more time that passes. And so in the law, we talk about notes that are contemporaneous, meaning they were taken either at the exact time that something was happening or very shortly after, when most people's memories are still very sharp. But obviously, the more time that passes, the more likely it is folks are going to forget things, they'll de-emphasize things or maybe exaggerate things. And so we really encourage that the documentation of these, and by this we're talking about the checklists and we're talking about the forms, that these be completed as close in time as possible to when the observations are actually being made. Frankly, 24 hours I think is a reasonable cutting off point, but I would really encourage employers or supervisors to do it more quickly than that. Supervisors should document every factor or every indicator that they've observed that contributes to their belief that there's reasonable suspicion of employee substance abuse. So no matter how minor it seems to be, it should be included on there. And again, the more comprehensive the checklist that you use, that you make available to your supervisors, the more likely it is that they're going to be able to meet that requirement. So that's, again, something we strongly encourage. Preparing the documentation, it's really important for supervisors to use specific language. So his breath smelled strongly of alcohol is going to be better than, his breath, didn't smell right, or she was sweating excessively. That by itself is not very good. But if you say she's sweating excessively, even though the office was the same temperature that it always is, and no one else in the office was sweating, that's very specific. Okay. There's any number of reasons why somebody may be sweating, and if everybody in the room is sweating, then it's a very useless observation. So it's best to be specific and rule out that question about whether anyone else was sweating or whether the room is warmer than it normally would be, for example. We want our supervisors to avoid speculating. We want them to avoid using any language that suggests that they've made assumptions, and particularly that they're trying to diagnose something. So some things that we've seen over the years, supervisors documenting that a given employee is going through a divorce, and so her doctor probably has her on some sort of medication because when I went through my divorce 10 years ago, my doctor prescribed something for me. Okay, I get that, but that's not we don't know that that's what's happened here, and so that's an assumption. There's some speculation there, maybe even a little diagnosis to the extent we're thinking maybe there's some anxiety or depression associated with this employee going through a divorce. This other point here, that he had a look on his face like he'd been smoking pot before work. Okay, that may actually be a fair observation, but it's by itself, it's not good enough. If the supervisor saw something on the employee's face that led the supervisor to believe the employee had been smoking pot before work, then that supervisor ought to be able to explain what it is about that employee's face. It may be that the eyes are half open, they're red, they're bloodshot. It could be the look on the face, a blank look on the face, something like that. These types of details are useful and will elevate this type of comment beyond just mere speculation or assumptions or attempts at diagnosis, which aren't useful, and will elevate it to an objective observation that will support potentially a finding of reasonable suspicion to believe that there's been a violation. All right, so we've got non-descriptive terms and descriptive terms that can be used in this documentation. We very much want our supervisors to avoid the non-descriptive terms. And again, there's sort of some overlap here, but saying that an employee was out of sorts or seemed to have a chip on his shoulder all day, that's not very useful. That means different things to different people. The employee was disrespectful to me. Here again, we all have our own ideas of what disrespectful is. So these are non-descriptive terms that aren't very useful. We need more descriptive terms. The employee that seemed to have a chip on his shoulder or seemed to be out of sorts, something like he yelled at Josie to mind her own business when she pointed out that his shoe was untied. And he accused Sue of trying to steal his cell phone off his desk when all she did was touch the screen so it would light up and she could see what time it was. And as far as the disrespect issue, she pulled her key card off her lanyard and threw it at me and told me to fire her if I didn't like how she was doing her job. That's a very good explanation or a detailed descriptive explanation of what the supervisor means when he or she says that the employee was disrespectful. So this is what we're talking about between favoring descriptive terms over non-descriptive terms and what ultimately is going to support a finding of reasonable suspicion to warrant the testing under those circumstances. Now, it's also very important that supervisors document everything that the employee says by way of explanation or the reasons for the observed factors, because at some point it's likely going to be necessary to speak to the employee about what's been observed, except under extreme circumstances when there's clear impairment or intoxication, as well as any other specific observations that are made during that conversation. These need to be recorded as well. So I put an example here. When I asked her about the sweating, she expressed surprise, pretended to be surprised, and told me that she hadn't noticed it. But I had been watching her for a few minutes before I went to speak to her, and I saw her taking tissues out of her purse and wiping the sweat off her face. And when I went up to speak to her, I looked in the trash can, and it was full of tissues. So she'd been, mopping the sweat off her face all morning. So, those are important observations. You're not only recording her offered explanation for why she's sweating, but she's also misstated something to you as a supervisor, and that's important when we're trying to ascertain whether or not we've got reasonable suspicion to warrant the drug testing. So we are past our time here. The remaining slides address the time frames, many of which we've talked about. The 24-hour rule for documentation is mentioned here again. I've been focusing mostly on what we're asking our supervisors to do in terms of determining whether or not there's reasonable suspicion, and I've not been focusing on how the actual testing is conducted, which is pretty much the same for all types of workplace-related drug testing, and therefore I didn't feel the need to go into all of that. But the drug testing should be conducted on the same day that the observations are made, if at all possible. Under DOT regs, and I think this is also important outside of the context of DOT regulated positions, is that the alcohol testing, if there's reason to suspect alcohol in particular in terms of substance abuse, and it needs to be performed within 2 hours of the observation, but certainly within 8 hours. And under the federal regulations, if we miss that 8-hour window, don't do the testing. And the reason for that is that alcohol testing is actually different legally, different category of testing from drug testing. In consequence, it's also a lawful substance. And so there are reasons why the Department of Transportation treats it differently. And frankly, those reasons make sense, and we likely should follow suit with those. But in any case, when testing is not conducted, or testing is not conducted in a timely way, that needs to be documented as well, because that may become an issue down the road. All right, so we're a few minutes past here. I don't know that I'm going to go into this last section on these practical considerations. This is just a miscellaneous catch-all. There's some important points in here, so I'll encourage y'all to look at the materials that Dan's going to make available to you. And if any of y'all have any questions about anything that's in those sections or anything that we did cover, as I said, please feel free to contact me directly, and I'd be more than happy to address those with you. I don't want anyone to have any unanswered questions following our webinar here today. So thank you very much, Dan. If we have any other questions, I'm happy to address those now.
Somebody had asked, can we share this presentation with our department heads?
Yes, absolutely. That question may have been asked because of the copyright on there. But yes, we make this available to our LGRMS and therefore its membership. And so if you believe that this would be useful in presenting it to your supervisors, then by all means, we're happy to have you do that.
Anybody else have any questions they'd like to ask Reed before we finalize the presentation? Well, Reed, thank you so very much. Really, really appreciate it. Great job. I got another comment. This webinar has been very, very informative, focusing on the facts. It's highly emphasized when being objective and subjective. I will definitely pass this along to my staff. So again, lots of great compliments. Great job, Reed. Thank you all for attending. Again, I will be sending out the link to the recording, the presentation, and other supporting document that Reed gets me probably either tomorrow or early next week. Thank you, Reed. Have a great rest of the day.
Enjoyed it. Everybody have a great day.